The cards speak. Justice listens. Welcome to the unseen. Truth doesn't hide forever, not from the eyes that see. Spirits stir, clues awaken. Let the seeing begin. Behind every crime, a shadow speaks. I'm Lady Zelda. Welcome to Seeing Crime. Hello there, everyone. Welcome to Seeing Crime. We are definitely getting ready to see something here. And we are all set up what we're going to do today. Bless you for being in here and welcome. Today is Monday, the first day of fall. That's right. Now, the motion to dismiss hearing between Paul O'Keefe versus Karen Reed starts at 2 p.m. I am going to be streaming Mike Crawford, the Young Jerks channel. He and I talked about that yesterday, so all is well. So what we don't want is 1,000 people calling into the Zoom, because I'm sure that there are, and we don't want to start getting disconnected. And since I would be calling first time and they don't recognize my equipment, my number, it's just better we do it this way. And so if you have not subscribed to the Young Jerks, which is Mike Crawford, please do that. He is a friend of the channel. We are a friend of his, and everything is great. So we are here today, and welcome, True Oracle. Welcome to everybody. I mean, I hate to say this, but we're getting a part of the old gang back together. It's going to be AJ, Alan Jackson, and it is going to be Eliza can't even talk, Eliza Little in the courtroom today. I don't know about you, but I'm stoked. So don't forget about your grifting psychic up here. Hello, we've got that going, and all is well. So as soon as they start, and I've got so he's got something going on right now. Let's tune in. Let's tune in. They're starting. Okay, my darlings, here we go. So I hear something with Cosgrove, I think. Give me a second. We're going to patch this in. We're just going to get started. That's the way to do it. You may want to turn up your volume just a little bit. Mine is up, but don't know. All right, so this is Mike. Here we are. And let me fix this so you can see.
Albert. Yeah, yep. See that.
And his response was?
Right now.
And that was at 1:34 p.m. and 45 seconds?
Yes, it was.
And you took that to be a question, correct?
Yeah, asking right now, yes.
I don't know about you guys, but I'm excited. I don't know what they're doing right now, but it is what it is. Hello, everyone. Welcome in. Hello, happy Monday to each and every one of you. I don't know what they're doing. They're replaying something from the trial. Civil hearing starts at 2. Let me see if I can boost this video.
I responded, yes.
You may want to turn this up. I'm going to turn mine down.
Yes.
You would have still been on scene at that time?
I'm not sure if I was still on scene. but I was obviously, if it was in the area, it must have been in the area, correct?
That sounds like Matt McCabe. Yes, Boda Bob, thank you so much.
Who responded to you?
Brian Albert again?
And his response was?
Okay.
Do you have a memory as to whether or not Brian Albert was on scene at that time or if he was somewhere else?
I don't have a memory of where Brian was at that time.
Given the fact that you're
Yeah, this is Matt McCabe.
asking right now,
I'd assume he's not, I'd assume he's somewhere else, yeah.
your response to him, or your response to the group, I should say, was what?
Sounds like David
I had
Yannetti.
to pick up a car, so I drove through.
So this is a little further than the top.
Oh, I know we're getting to the next.
I had to pick up a car.
So take this one down, please.
I mean, 7 more window, I'm sorry.
Park it in the. Oh, I've got something for all of you. We're going to park it in this. You ready?
The garage, essentially. Is a garage, essentially.
The garage. The garage.
Yes, the second bubble, please. This is
I'll be right back. Talk amongst yourselves. AJ looks good.
Okay. Now we're at 1:35 PM and 16 seconds, Mr. McKay.
Yes, that's correct.
And your text to the group of you, your wife, Brian and Nicole Albert is what?
Trying to get pictures.
All right. And at this point, I've asked the next bubble be displayed, and then I'm going to skip to the bubble after that once you see it.
Garage. I have no idea, Kelly. I have no idea. Let's look at it again.
The garage, essentially. Is a garage, essentially.
A garage. I had to do that. We will no longer be without. Garage. Oh, Louise, thank you so much for being here. So glad you could make the live stream. Hello and welcome, everyone. So happy that you're here. Oh no, Wildwood, 4 a.m. Well, thank you for spending the early morning hours with us. It is almost 2. We have 6 minutes before this starts. I'm glad that you're all here. Thank you so much. This is kind of an impromptu, kind of. And you know I don't do daily streams, but I wanted to do this one. Garage. Here we go. There's Ted Daniel in the court. The Reed family, Dr. and Mrs. Right, Louise? You know, Dr. Reed is a very striking and handsome man. He really is. There's the O'Keefes, Paul and Peggy. There you go, equal parts. Absolutely. Hi, Mystery Singer. Hello, welcome. This is going to be interesting. This is a civil side, everyone. Motion to dismiss. Hi, Amy. Bless you, my darling, for being here. Yes, it will. I have a really cool announcement when we're done with this, too, and I know that all of you will be. Karen looking stunning as you. I don't know how this young lady does it.
All right.
Good afternoon, folks. Good job, court now in session. Please be seated.
Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with Plaintiffs' Counsel. And if you could state the party you represent as well, thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Okay, good afternoon.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Okay, good afternoon.
Good afternoon, Your Honor. Charles Waters for defending Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a
Judge Daniel
60-day,
O'Shea.
whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
The
Right,
DA.
but we've also, I anticipate that the
Lazy.
defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days is my guess.
Typical
Okay.
DA's
All
office.
right. Procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity,
Yay.
Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend,
I do
Your Honor,
too.
to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who are the occupants of 34 Fairview Road in Canton
Yes.
on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights,
Yes.
and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in.
Oh
To
my
do
God.
that, we would
Voluminous.
be alleging that the individuals in the house diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the house were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the house was not explored and investigated.
What?
And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted,
Look at her
made
face.
to face 2 criminal trials
Get him, girl.
for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Dillard can have an
Well,
opportunity.
at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claim should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right, let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff. We're under extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Agreed. Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but when there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, then.
Your Honor, this similar vote as to Waterfall. We were putting finishing touches on our discovery responses. The last leg of it is just collecting communications from employees in that incident, some of whom no longer work for C.F. McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then in terms of the response to the procedural issue that was raised in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not
expect
how the court
that-
system likes this stuff to work, folks.
Right, I would expect the courtesy of the meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have the state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right, any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But
place.
it is, though. It's the plaintiffs. Well, just hear me out for a second. When you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So with this, at its essence, is a wrongful death action being brought by the plaintiffs, right?
I think they
So what you're
expected it.
seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them the new parties of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case. Correct?
Yes,
there's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way we could, you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But you have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time. Just seems to make judicial sense. That's why we're raising it. We'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have the burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I certainly am not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is no, the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene.
Don't you love him?
And the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon
This man is Seligson.
many hours later.
The judge
There
is
are
Daniel
cases,
O'Shea.
and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. The waterfall?
Yes, Your Honor, we have the waterfall just very briefly. I think the distinction here the council's making is that these claims, infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't from a relational standpoint close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No? Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely. You know,
allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the
No,
ones
you don't
that
know
will
the
be at
facts,
issue
sir.
here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives
Notice how
drunk.
she doesn't watch
She
him.
reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family
There's a
learns
man in
of
the
JJ's
snow.
injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information.
I wondered how long that was
him.
going to take.
She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Semino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Semino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Semino case, Your Honor. Semino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court. And I see no reason why this court should overturn the good standing law that exists under the Semino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that, does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury, contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions. To suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. that is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the
This
defendant
isn't
argues
Aiden's
that
case.
this is not
Sit down.
extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability. And yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous, it's at the time of the event, and the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that it might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to sign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it, but nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it, and ultimately a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers, your clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. The clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have the mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make ultimately. They're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you you could do as soon as this spring if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do what.
We're agnostic, is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay,
Either way, Your Honor.
okay. All right, we'll do it in person. Fine, we'll do it down here in Plymouth. I will be moving into the Brockton Court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
How many days out do you want to go for? 60 days, 90 days?
Yeah, probably 60 days.
50 days? November 21st, Friday in the end of November.
Yeah, that November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery. And any motions, Rule 15 motions to amend or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor.
All right.
Nothing with the jury?
I don't think so.
Nothing with the jury?
Yeah, all right. Yeah. Thank you.
Okay, my darlings, that was something else, wasn't it? What do y'all think? So this is Judge Daniel O'Shea. We were in the Plymouth Superior Court, and the attorney that was discussing things for the O'Keefe family, his name was Mark Diller. Now, I'm not an attorney. I'm going to comment on a few things that was said. So just so you know, not a lawyer, not a doctor, not an Indian chief, tarot profiler, but I also have experience with other people. Now, I did invite Attorney Nan to come over. She said she was actually listening and sitting in another court. So, I mean, we never know. She may be able to pop on here in a few minutes. We don't know. But so let's just say this. This is, if the tide of this battle were turned, AJ and everyone else would be doing the same thing as the O'Keefe family. Now, because the law states that they can do that. Just remember the civil claim when it was O.J. Simpson. He was found not guilty, but they nailed him on a civil claim, and sometimes that happens. However, in this particular case, there's so many moving parts. Seriously, so many moving parts. But it made my century to know that there are those 10, is it 8 or 10 people, including the McAlberts, including all those people. And plus they said, I don't know if you caught that, but it was, all the Canton MSP and all this and this and this and this, the McCabe family, there were 10. But I think they're leaving that open because they said for all those people who were there at 34 Fairview, does that include Sarah Levinson, Colin Albert? That's a question I want to know. Dr. Reed is a class act as far as I'm concerned. But I have to hold, I'm going to tell you, Karen has been what do I want to say? Helped. That's the best thing. Karen has been helped tremendously because I watched her. And there are certain things that you do in court to remain believable. First and foremost, the way she was sitting. Hands folded in her lap. Wasn't sitting there doing the thingy. She was dressed conservatively. No big earrings, no big jewelry, no nothing. She dressed conservatively because I'm going to tell you this. Pardon me, that was my ring. People who go into important meetings, even court, even an employment meeting, many things, dress incorrectly and then wonder why they have problems later on. Now, I'm not saying that you can't be the individual you, but I will be saying this. If I were to go to court, I would not be wearing my earrings, red lipstick. I would really, because you don't want to bring notice to yourself. I saw Paul and Peggy making a few faces, but the one thing that I will tell you is this. If Karen Reed's team, and they did say that they were going to be suing the MSP and these detectives, which most likely included Tully. I did not hear his name, but that doesn't mean anything because they went through it pretty quickly. Lindsay Catani, remember her little statement. Lindsay Catani is suing Tully. So watch, because the moment that they drop Turtle Boy Aiden Carney's charges, he too will be suing Tully. Now, I'm going to tell you this, okay? Let them say what they want to say. Let them look like fools. Let them. Legally, they can say that. They can have an opinion just like anybody else. She was found not guilty. She did not hit John O'Keefe with that car. That doesn't mean that they still don't have an opinion and an attitude. So let's think of something a minute. A couple of things. I wrote some things down. This attorney, Mark Diller, kept saying that she was pitting, Pitting, pitting the people against the O'Keefe family. She went on the Turtle Boy Aiden Carney show. Now, I don't know about you, but I don't know what episode that was. I would have been there. Alan Jackson went on his show, but not Karen. They're wanting to just put out there that Karen is this nonsensical, flighty, ridiculous woman. And when the defense team gets up to the table, they are going to be able to say, we have a credentialed woman here who doesn't need to back over a man to feel satisfied. Let's remember the 911 call. Yeah, hello. We got a man out here in the snow. We got a man out here in the snow. This is going to be a very exciting next 18 months and beyond. And believe me, if you're watching the McAlbert family or any of you people, I have a little psychic advice for you. And that is, number one, it's too late. Number two, you better lawyer up. And number three, you better get your checkbooks out. Because I believe, in my opinion, now that's not the opinion of the defense team, and I'm not a lawyer, but I believe that one of the strategies of the defense team is going to bust you financially, because you won't have the people behind Karen. Let me re-say that. You won't have the people behind you like Karen did. And Karen does. And most likely will be doing fundraisers for. Again, you don't have that. So where are your funds? These people, Reddington, their lawyer, Mark Diller, get your checkbooks out. Because every time they receive a call from you, and I know you're so used to calling the DA's office and pulling the punches, that ain't going to work now. Because every time you make a phone call, every time they look at your file, every time they receive a phone call, they receive a fax, an email, or a text, they will most likely bill you in 15-minute increments. Don't know how much that's going to cost. But they're not going to be able to go in and plead the fifth to get out of it. Well, they could. But pleading the fifth in this, look out. There's going to be many twists and turns. And that includes for Meatball Morrissey too. Going right into this game, we see exactly what happened. The prosecution could not, they knew today was happening, but they could not even get their act together to get the plaintiff, the O'Keefe's, the discovery. And what did they do? Well, the defendant has that discovery. Sorry, pal, you wanted it from the prosecution office. You deal with them this time. Good luck. Good luck. They're going to hold your case back, because now, listen, talk about an enemy's enemy is an enemy's friend. They're all going to be mad. They're all going to be very, very mad. And they will aggressively, these lawyers will not take pity. The lawyers for the bad actors are not going to say, well, we know that you deserve sue. Because by the time, even if they did win, the lawyers got their percentages, wouldn't be a lot to split anyway. So what are they doing this for? You see, this is the O'Keefe's fault. I'm sorry. In my opinion, it is their fault. They pushed this. And now, I wonder what's going to happen when Jennifer McCabe calls Peggy and wants to know something that's going on, because it's because of Peggy that Jennifer McCabe is going to have to go in there. They're not going to see it that way, but that's exactly the way it is. And when this attorney and when their stance are saying that the Karen Reed and why they brought up Aiden is beyond me. He's not even in this case. But the reality is they're trying to say that she pitted everybody know, and it is my opinion, and most likely the opinion of my personal channel, is if this were my son, the buck would not stop here. And I think that's the way everyone thinks. We don't want harm to come to the O'Keefe family. We're beyond that because we've got our noodles and we think correctly. We're not petty, we're not arrogant, and we're certainly not vengeful. But what we do want is we want justice for John. And we know some ringleaders, we know who was involved, and we know the last ones that saw John consciously alive, and it was not Karen Reed. When they start going through everything again, because think about this, they're going to be calling experts. They're going to be calling experts. They're going to be going through this all again. They might even call these doctors back. I don't know. It's going to be depending upon them. Listen, I know by the look of Karen, she was sitting there giving straight ahead looks. A couple of times she looked at Mark Diller, probably about the same that she looked at Hank Brennan. But you know what? She's a much better woman than me, because I would be really giving him, but you know, that does not look good in front of a judge. It is not professional. Believe me. So we've got, I remember when this case was over, June 18th, when Karen was acquitted, it was like the next day, everybody's like, oh my God, what are we going to do now? Well, congratulations, my friends. We have now entered phase 3. Phase 3 will definitely give us some better insight. There will be more that they can bring up in their discovery, including, but not limited to,
the garage, essentially. Is a garage, essentially.
The garage. So there's many things that they can bring up. So let them spew their lies. Let them spew. They have the right to say what they did. Doesn't mean it's right. It just means that that's one man's opinion. And you know what they say about opinions. So this is a good question. Zelda, when OJO came to you on Christmas Eve, he told you that he was in the basement, correct? So I think they pulled him up from the basement because of the stuff that he had been missing and the so many leaders, and maybe put him in the garage until, I believe so. And I believe, now this is my own opinion, don't have facts, but I believe that that's why they did this. Let's clear out the house automatically. Let's make people go. Let's distract Julie Nagel and Saren Levinson. Isn't that the ones that the Jawbone Jen was driving down the road and she's turning around and distracting? Because it's my understanding that even when Attorney Nan, our friend Attorney Nan, went up there, she said that place is so small, it would be very, very hard to miss. And if Matthew pulled out of the driveway and went in front, his headlights are going to shine right on the snow. So they needed to clear out the house. But then it was Julie Nagel who said, I thought I saw a black blob. What? So believe me, these people, so all of the players that you saw, that we saw testify in trial 1, and the majority of trial 2 will be in this. Unfortunately, depositions cannot be televised. but we will be finding things out, and that is for definite sure. So I know, as enraging as this is, I want you to relax and I want you to start grinning, because this is the petty world that Paul and Peg O'Keefe unfortunately live in, caused by Jennifer McCabe. It will be Carrie coming. It will be many things. It's just going to be a mess. And this will be, pardon the maybe grotesque part about this, but this is going to be regurgitated over and over again. AJ will now be able to get Jennifer McCabe in depositions and look at her and pound her. And she's going to have to answer. She's not going to have a judge to say, Mr. Jackson, move on. She's not going to have anybody. The lawyers can object, but only as to a certain degree, because it's considered to be discovery. Frankly, Stamping, that is an excellent question. How many testimonies do you think will change this time? Well, I can tell you that as of tonight, there will be meetings starting to happen somewhere, somehow, some way, so they can all get their stories straight. But as much as they did that, don't have too much confidence in that. Because you see the testimony of Brian Albert, Higgy Baby, and Nicole Albert, and Jennifer McCabe. All four of them did not know where Higgy and Brian were at 34 Fairview. One, they were in the basement. Two, they were upstairs looking at the Marine. The other one, they were in the family room. Nicole was in there. She was not in there. So believe me, the truth will start coming out. And I know that our friends, agents Oobligada, are going to be sitting there just like, because they already knew that Karen was innocent and did not do this, and recommended that the DA's office not bring charges. But guess what? They needed somebody to blame because they had to take Lucky off the table. So who would it be? The fact that Jennifer McCabe, if you want to know the truth, I'm going to get real close, I think, to the time that this happened with John. I believe that this happened with John between 12:20 and 12:23 a.m. January 29th of 2025. Within several minutes, just a few short minutes of him going into, and the fact if he went into the garage first, hold on, you know now what we got to do.
Garage, essentially. It's a garage, essentially.
If he went into the garage first and then went down, but he showed me that things started in the basement. No one else knew this because they were all too busy doing their own thing. And Higgy was too busy lying in wait, in my opinion. I feel that he received the final blow in the garage, essentially, because of the testimony of Dr. Lapazada. Dr. Lapazada said that you cannot sustain an injury in the head, and especially in the back of the head. And just so you all know, the reticular activating system is a real thing. It was the reticular activating system is a bundle of nerves that relays all of your body through. It's a relay switch that goes up to your brain. There. Anybody who has a medical degree, I'm sorry, I just plummeted that. It's called the RAS, the reticular activating system that we also talk about in the laws of attraction. But if you destroy that reticular activating system, you have only seconds. Now, again, I'm going to tell you, I need to bring this up for a reason, and we're not going to get started, and I don't want to get started on this, but the loss of life, September 10th, of Charlie Kirk, he was gone within seconds. Why? Because that split things, and his reticular activating system lost contact. He basically did not know what hit him. That's the opposite of what happened with John. John lingered for a few seconds. He knew. He knew enough to know that he could not get out of it because, let's not forget about Chloe. I do not believe that Chloe attacked John, in my opinion, in the garage. I believe that she attacked him downstairs in the basement. And then they had to do their thing. And Higgy Baby, I believe, in my opinion, because John told me Christmas Eve, when everything happened, they moved him to a cold, dark place. Now, the cold, dark place, that would have to be the garage. However, I believe something happened in the basement, because let's think about it. Why would you tear up the flooring? Why would you make such a big remodel out of something if nothing happened down there, right? So there was that event, the clearing of the house, they move him to the garage. So technically they didn't lie on the stand and say that he was in the house, because he really wasn't. He was in the basement and in the garage. And then I believe in my heart of hearts, he rallied enough to get up. And that's when the final blow happened. Because according to the testimony of Dr. La Posada, that sustaining that type of injury, lights out at that point. It's only a few seconds. So he was still breathing when he was on the front lawn. But now let's think of this. He showed me where they took around the back of the house. Funny, but then we see these pictures and videos from AJ. Let me get rid of this banner. It's distracting me. Thank you, Mike. Then we see pictures and video from AJ going through the bulkhead and out around to the back of the house. Why? Because opening a garage door at 12:30, 1 a.m. in the morning, whenever it was, is going to wake up the neighborhood. Somebody, especially Mrs. Chung next door. See? They thought they knew what was going on. And plus, he had the back pocket ripped. Why would his back pocket? How would a back pocket? That's not really a target area to go for. Except if you're dragging someone on the ground and you've got one leg up in the other air and your hip that your pants are ripped on is on the ground and it's ripping. Remember, John was over 6 foot, I believe 6'2", and he was over 200 pounds, 216 pounds. He was a good sized man. Now let's say this. At this point, he was dead weight. Most likely where the 5 fingerprints DNA came on, because everybody was trying to, not 2025, that's right, I'm sorry. 2022, I said 2025, sorry. Because everyone was trying to get him to move. Think about it. Plus, they had Chloe to deal with. So everyone was scattering. Everybody's scattering. And he had grass stains on his jeans. That's exactly right. A man like John would not have grass stains on his jeans. So he had one butt cheek on the ground, the other leg was, and they went out through that side gate and left him right there. Then here's where my questions are. And yeah, we can start these questions again. My questions are this. Give me a second. I think Miss Nan sent me a message. Because we got to keep Miss Nan in the. No, she's in New Jersey. Gotcha. Okay. Thank you, my darling, if you're watching. I think she may be. Everybody wave at Miss Nan. But she's in court. She's got probably another hour. So she's probably not going to be able to come on. Who was it that made this decision? It had to be a collective decision, and quickly. Think about this. I do not believe that they intended to do this except to beat him up, rough him up, teach him a lesson. And then things got out of hand because by that time everybody was charged up and wanted to get their licks in. You know how it goes. I don't believe that they had that intention. But and for those of you who wish that Sammy would turn the printer on, she just did. So you manifested that. You got your wish. She's standing there looking at me mad because I'm not holding her. So there's this burning question that I have, and I've kept asking John. And yes, I have had, and look at this person. This is Captain Jerry's boyfriend, the shaggiest of noodles. So I want you all to think about this, and this is the heartbreaking thing. Sorry, I've got allergies, so if you see I didn't even hardly put any makeup on because, and that's the way it is. It's the shaggiest of noodles right here for your enjoyment. Look at him. Oh, he sees my son. You see this little, he's got a little blaze on his nose. You know, this little, like, I told him that when God was painting him, he slipped with the magic marker. And that's why he has that little mark there. Yes. So anyway, let's think about this, my darlings. And then I've got to make like a bakery and roll. The fact, because he got to this certain point, and John showed me where they took towels, white towels. Now, who uses white towels in these types of things? Thank you so much. people like The Sopranos. Thank you. People like The Sopranos. So he told me they held, and I think at first they thought, oh, because you know, sometimes there's some areas on your body you get a little cut, and it just seems like, good grief, there's 15 gallons, right? Hello. Only in this case, it was what, 3 liters that he lost? So, my point, my darlings, and I'm getting to it. My point is there was a point that they knew he was not going to come back. They knew they had to do something. They knew. How? Why? Because if he would have recovered, he would be testifying that Karen did not hit him with her SUV, and it's these cranky cranks that are responsible. They had to make a snap, collective decision. We better take him out. Can't testify. So, did somebody in court today say dead man can't testify? That's very true. Can't testify. So they had to make this a thing. They had to figure this out. That's chilling, if you ask me. That's chilling. Think about it. Because if they would have really seen that he was, as my grandmother would say, boogered up, if they would have seen that he was pounded, they are the ones responsible. They should have called 911 the moment that he started showing signs that there was a problem. And he may have lived before that fatal blow to the back of his head. So where does the responsibility for our buddy John go? Hello, everyone, and thank you so much for coming in. Needs more K-Bell? That's correct. They can't testify, but they can speak. And believe me, the evidence for John will be speaking for themselves, for itself. Because, listen, my darlings, I want you to start smiling and forget about today and forget about what they said and forget about all these, because we knew they were going to act like this. We knew it. We knew they weren't going to go in there and say, oh, please, let us just go ahead. And I know they want a motion to dismiss, but we don't want one. Okay, Your Honor? No, they're going to rip her to shreds. This is a civil case, and they will be taking depositions from Karen as well, and they will not be pretty. But the great part about this, you know why she can sit there and take this and do it with a smile on her face? Is because she's innocent. She's innocent. That's why. So, cheers, my darlings. Just a second. Pardon me. Sammy left a little something behind. So all of this is going to come out. And one day there's going to be a new DA in town. And I know some people will say, oh, well, wait a minute. That investigation was botched. Doesn't matter. If they have discovery. I've seen people get indicted and worse over circumstantial evidence. And that is exactly what Karen wants to come out. In this discovery, they are going to be proving a lot of circumstantial, I can't even talk, circumstantial evidence. And when we see this, my darlings, yeah, Rose, I mean, pretty much every judge is going to say, look, if you can work this out, all it is money. But see, I think the judge knows to a certain degree, but I think that he's saying this. I mean, you're right. We can rest because AJ as leading the pack on this. Eliza Little is also here. This is going to be amazing. And third-party culprit is now taking a different third-party defendant, not culprit, pardon me, not a lawyer, remember. Third-party defendant, oh, Karen, and I'm going to tell you this, a long time ago, in a land far away, a long, long time ago, I read that this was not ending, that these people would be answering, and they too would be involved. So yeah, Karen 3.0 is exactly right, Amy. And not only this, my darlings, buckle up. And you never knew, maybe one of these days we can all get together for a meal of food. And where will we get together? I don't know.
The garage, essentially. Is a garage, essentially.
Probably something like that. So once we get going into this, and it will be next year, because if you were not here Saturday evening, Attorney Nan graciously offered to write a letter of introduction for me to go to 34 Fairview when the time is right. The time right now is not right. And we're getting into the holidays are barreling down on us, and I don't fly. I'm going to be I will drive, and I know there's somebody in the chat, they'll say, I'm driving. So yes, I know she is. So, and Attorney Nan will be going with me. We will be documenting everything. My darlings, do you really think that there's only one? That there's only a handful of people that are going to start documenting things? So yes, Captain Jerry, absolutely. So just now, wait. Now, I got another little surprise for you. Oh, hold on. I dropped something and I don't dare. I got to tell you something. Let me say this. I had these stunning earrings on. What day is it? Yesterday? Beautiful, big, dangly. I was holding Shaggy when we were done. This one fell out. I did not move. I'm here. Do you think I can find it? Second time it happened. If it happens a third time, then I'll know what's going on. So I just want you to know that. No, I don't. Because there's a difference between being a cop family and being arrogant. Just like I said Saturday night, don't know if you were here Saturday night, but pardon me, taking the ring off because I'm a smacking it. Good. Say hello. There we are. Many times in investigations, I will go out to a place and I will take a black light or something with me because you just don't know. You don't know what you're going to run upon. Was the garage looked at? Probably. But those things are very hard to clean up. Those stains are almost impossible. Gee, why do we think that the basement was renovated. Pulled carpet pulled up, subflooring pulled up. And them saying, yes, well, there was a plumbing issue or something. Plumbing? What? So no one is off limits. That's exactly right, what AJ said on Billy Bush. So this is going to be very interesting because everybody is up for grabs. They may not even limit themselves to 10. I didn't want to do that because there's a lot of energy in the court, a lot of energy in the chat. There was a lot of energy coming from Mike's. Good idea. I literally thought about it, and that's great. I've not pulled any cards yet because I've been here. So there we go. I can tell you that he maintains the uncomfortableness of what's going on. He's very uncomfortable. And let's not forget, my darlings. See, the timing of this is so fantabulous. Don't forget the mega motion that came out for Aiden this past Friday, in which we have redacted text messages. Listen, if I were Jennifer McCabe, hypothetically, I would be wiping out the back of my pants. Seriously. Because she's getting it from somewhere. They're separated. Jennifer is getting it here. She's getting it over here. And there ain't no help coming, Jennifer. Nobody's coming. Mr. Reddington is an excellent attorney, but Dr. Turk still went to jail. And it's kind of too late now. Listen, folks, it's never too late to fess up. But at this point, it's a little too late. It's a little too late because I'm going to tell you something. If anybody fesses up now, they're going to start looking at grand jury and testimonies again. So, yeah. No one coming. Carrie's going to be your best friend until you throw her under the bus or until her husband finds out your activities and that you used his wife. Because that's exactly what Jennifer did. She used Carrie Roberts, and Carrie was one of these girls in high school that just wanted to be popular. She wanted to run with the popular crowd. Well, then, after this happened, she leaped on the ability. Pardon me, just a second. Pardon me. She leaped on the ability to be involved because Carrie is one of these people that needs drama. She needs drama in order to feel like she's included. Jennifer used her, just like she's using Peggy O'Keefe. Don't know if you know this, but Jennifer has been known and told a neighbor one time when they went out drinking, whatever. I think it's easier to say when they don't go out drinking, but when they went out drinking or something, she told someone, look, watch. I can manipulate that guy. I can send a vibe to take a drink out of a beer. Now that was, thank you so much. That was So, my darlings, I would be laughing because think about this. Carrie lied to the grand jury because of what she felt Jennifer was gospel. So you see, that's pretty maniacal. Sociopathic, I think, in some regard, in my opinion, possibly, and never know. Not a doctor. I'm not going to diagnose, but wow. That's right. And remember what Karen said about Jen. There's only one of us going to go down. It's going to either be her or me. Well, guess what? We're going to see. We are going to see, my darlings, who's going to get it. And it's not going to be Karen. So I just want to announce tonight, because I am feeling like a puff adder because of allergies, and I've got to catch up. I've got readings that are like stacks of readings. So, my darlings, I'm preparing for a post office trip this week. I am preparing for, I'm going to get the majority of these readings done, so no one has to wait. Pardon me. Hold on. Another one is coming. Hold on. I'm going to leave you for a second. I'm back. I'm going to have a good meal of food. I'm going to think about buying a house with
a garage, essentially. Is a garage, essentially.
And thank you so much. Thank you, my darlings. And so I'm sorry we're not going to have Manifestation Monday tonight. But I think that I would be a mess if we did. Thank you. So, my darlings, now listen, this is getting exciting. And if you're on any of the other platforms, I want you to follow True Oracle and myself on the Book of Faces. I want you to follow, and if you can share, please do blah, blah, blah. And share, like, comment, subscribe. I have a little competition of my own. So I'm going to hit it hard, my darlings. You're going to be seeing a lot. So anyway, here we are. Amy, 7 o'clock is a better time for us, because you remember originally it was 1 o'clock in the afternoon. We got no views. So, but it's 7 for me because remember, I work another job as well. So I always have to maneuver. So anyway, my darlings, I have a little competition going on within myself. So if you can share, like, subscribe, comment, we're going to be getting a lot of people, but I'm also going to tell you what to do, what we're doing. Thank you, my darlings. I'm going to tell you what we're going to do. On Thursday nights, because I'm going to tell you, first of all, your giving to the grifter helps to keep this channel going. Okay? And so do your memberships. It keeps me going so I can spend more time to bring quality content and quality videos to you. I always want to give back, and I'm always thinking of the best ways to give back. That's why we have giveaways. That's why we do what we do. But I've got a fantastic giveaway coming up, and I'm going to do it all the month of October, and I'm probably going to start this Thursday. You guys are going to love it. Now, first of all, look at this. Thank you. First of all, what was I going to say? Well, it's a joke, my darling, because somebody said that on the Twitter, and it's just fun. I don't care. It's fun. But thank you so much. And if you can think of me, because you know, the tube takes 30. The tube takes 30. That's just the way it is. The tube takes 30. And they pay once a month. And that's fine. I'm fine. That's good. But if you can consider to keep us going and keep going with, you know, I'm not going to tell you who it was because you guys would be appalled if you knew who it was. So just, I appreciate that because I'm just going to say it this way. The more you donate, the more you keep up your memberships, the more quality and the more giveaways, and the more merchandise, and the more special little things that I can give back to you. Okay? So, Wednesday night, tomorrow we have off. Wednesday night, we have our darling Janet Misdemeanor. That's Wednesday night. She's going to be coming on here. We're going to talk about cases. We're going to do all kinds of things. On Thursday night, we're going to have Help, I'm Haunted at 7 p.m. and we're going to have a blast. On Saturday night, we're going to have Seeing Crime. We've been seeing a lot. We're going to do more EVPs. We're going to do I'll probably have something a little bit more paranormal. And also I can start having lunch with you and going to do all kinds of little goodies type things. But I'm going to tell you what I'm doing. I know y'all love Help, I'm Haunted, and Miss Jerry told me, and y'all have to vote. We're going to have a vote Thursday night, but I think y'all have to vote. Thank you, Tilly4444444. Thank you. But Miss Jerry says she thinks that I need to have Help, I'm Haunted all year around. And if that's the case, I need to get my butt out there and get some more stories and get some more paranormal investigations and do some more things. Now, remember, we're going to have the Haunted Gallery, which I'm going to put the painting up of the Monticello, and we're going to watch that. We're going to do a little bit of that. But I can't help myself because I have to tell you what I'm going to be doing. How many in here? Let me say this. How many people in here used to watch a show on Discovery called, oh shoot, what was that? Boy, I lost that, didn't I? I've got so many stories, Kelly, believe me. I've got so many stories. Thank you, Debbie, you little darling, you. I got to tell you something. So I'll think about it. I got to tell you this. Last night, someone gifted my son and I on DoorDash. Ready? 2, count them, 2 cotton candy blizzards. And do you know how much it cost that person for 2 large to have them delivered on DoorDash? $30. It was like $32 to send me a gift. What? Cotton candy blizzard. It was so sweet and wonderful. I don't need it because I'm cutting. I'm watching. I'm cutting. But $30 for 2 cotton candy blizzards, they were, it was wonderful. Believe me, they upcharge everything. That's for sure. So anyway, I'm trying to think. It was something, the files. Oh shoot. Let me see now. I gotta find out. Give me a second. Talk amongst yourselves. Oh, what was it called? The Holzer Files. The Holzer Files. Does anybody thank you? Thank you. It's the Holzer Files. Holzer, thank you. Emily. The Holzer Files. Well, I happen to be an acquaintance of Shane Pittman. I loved that show, and I was so upset when Discovery canceled it. But now I got to tell you, the band is back together because Shane Pittman has a streaming service just like Netflix, only it is all paranormal, and it is wonderful. It's movies and investigations and paranormal. And now the band is back together with Dave Schrader, psychic Cindy Kaza, and Shane Pittman. I got to tell you this. That starts streaming, that particular show, it is an exclusive on the streaming service called Beacon TV. I am a member of Beacon TV. It is fantastic. But the Holzer Files was about this gentleman in the 1960s who would have, you think Zelda is like old-fashioned with the stuff, would do a reel-to-reel tape recorder, and he would go out and do investigations. Well, what they did was, Hans Holzer is the name. What Dave Schrader, Cindy Kaza, and Shane Pittman did on this show on Discovery, they went back through the Holzer Files and revisited, and they were wild. It was good. It was some of the most true. Well, they've canceled this show anyway, so if you know, but they are some of the most true investigations on television that I have seen. I see some other people on YouTube that are pretty authentic as well. Shane, Dave, and Cindy all got together. They're doing this new show, Paranormal Mysteries, I think is what the name of it, or Mysteries of the Paranormal something, but is exclusively on Beacon TV. It is a subscription. What I am going to do for one lucky person, probably this Thursday and through the month of October, is have a giveaway to give one of you a subscription for 1 month so you can watch all the paranormal shows that you want to watch, and especially these types of investigations because they are real. Shane doesn't script this stuff, But I'm also going to tell you, any of the ones that you see, on Netflix or any of those, there were some that were heavily scripted. People could only do and say what they wanted to do. And it's just like Ghost Adventures or any other of these things. They take hours and hours and hours of footage, and then they just parse them down just a little bit. And that's it. Very good question, Kelly. Lady Zelda, how do you determine who is doing real investigations? I'm sure there are criteria you go by. Yes. If it is with a streaming service like TLC and Discovery, used to be there for a minute, it used to be that discovery, they went from cooking and all that, and they went into whatever, and then all of a sudden they went paranormal, and everything was paranormal. Pardon me. When you see these shows that they say, oh, somebody's called in and they have this hurtful situation with this, and and it reads kind of like a movie, and it reads well, just kind of, they want to keep this step by step. I mean, obviously they have to, right? It has to. That's when Now, there are things that happen in the scripted paranormal that I have seen and heard audible voices. You can't fake the equipment, but what they do is they play act. I mean, it's like, oh, when you open the door, right? Oh, hi. Like you've never met this person before. They all go out, they look over the location, they make sure that this is the person they want to do something with, and then they kind of script it from there. So that's how they do it. I like a lot of the shows on YouTube because they're not scripted. And I can tell you this, when I do more of those, they will not be scripted either. You will not see me do scripted investigations at all. I go, it's organic, be the way it is. That's the way it is. And if I find something, I find something. If I don't, I don't. And that's how you know something is scripted, because quite frankly, your entities, spirits, ghosts, orbs, black masses, and all that other stuff don't perform when you want them to, right? Sometimes it does, sometimes you don't. And sometimes you can walk away. I mean, there have been times I've been on investigation and you sit there and you're so bored, you want to play cards and everything else. And the moment that you get ready to leave, and there's one place that this happened with, we were all getting ready to walk out the door and we hear a voice in the house go, why? So what do? We unpack and we go back and we sit another few hours. So it's not anything that you can control. So that's why these things are scripted, because it's hours upon hours. Because when was the last time you ever went and you saw a paranormal investigation and they sat there and said, well, there ain't nothing here. Nothing up my sleeve. Well, what are you going to do? Nothing's happening tonight. So got to have the views. I like the dead files. There are some that I just can't hack. There's a couple of psychics that I can't, that are extremely opinionated and extremely politically opinionated, and that has nothing to do, it has nothing to do with what we do. So anyway, that's it. When TAPS first came out, TAPS are a little bit scripted, but Jason Hawes and Grant Wilson are pretty much true to the game. Pretty much true to the game. Yeah, so there we go. So you have a reveal at the end, and that's pretty much it. But the other things, when I go to places, I want to find out why it's being haunted and what you can do about it. See, many times people go out if you're just going to look, announce to the people that have the place, look, we're just lookers. We're going to see what we can get. Okay? But then, they go out and they stir the pot and they stir up all this entity and all the orbs and everything else. And then they leave and they show the person, hey, you do have ghosts. Congratulations. We're seeing now. We're going to go back to our headquarters. No. We're not going to do this. I got to tell you this. My son was young, very young. And of course, we always loved taps, and they were at the St. Augustine Lighthouse. And that you may be able to find this episode on YouTube. I don't know. But they were in the lighthouse. Lighthouses are scary to me. I don't know what it is. Lighthouses are just a little bizarre. And there in this lighthouse, I mean, my son and I, and those were the days that my son would get spooked, right? And he would sit real close to me. We'd have to have snacks. Hello, you got to have snacks or you're watching that stuff. And all of a sudden, you saw this dark mass in the form of a person from the waist up do this and look over the railing down at them. There was no one up there. Now, that was not scripted. And that was long before AI. That was long before, and my son freaked. I mean, seriously. It was like, oh my gosh. He knew what Mama did, but he didn't know to the extent what Mama did. So that was crazy. I love lighthouses. I was at the Montauk Lighthouse. But, to me, they're creepy. They've got stories. So yeah, my darlings. Yeah. So that's what it is. So if you want to check them out, go to Beacon TV. And let me just write it here, because I spoke with Shane this morning and told him, and he said, oh my gosh, how are you doing? Blah, blah, blah. It is Beacon TV. Go over there, check it out. Check out the new episodes that they have coming. I think it's either on the 26th or 27th. And I want you to, if you want to see good paranormal stuff that's not scripted by the big box companies, right? I got to tell you something. I know a couple of people that were on Netflix, pardon me, on a couple of those series that they had. By the time they did not pay for their travel, by the time that they stayed there, they did this, they did that, they only made a couple of $1,000s each. And I just didn't think that was right. And it was pretty wild. So yeah, it wasn't that fair. It wasn't that fair. They have 3 different subscriptions, and I'm going to give a 1-month subscription. It's a value of $4.99. But you know what? You get content that's going to take you into Halloween. And if you like it, you subscribe. And if you don't, you got to see the content. And I would be binging the absolute fire out of it. So that's one thing that I'm going to be doing as a giveaway. And I appreciate it. Okay. So let me see. I've got some things here before we leave today. Curious Cole, hi, my darling. Shine light on darkness. Thanks. And thanks for your generosity. I agree. And there is a sweet face that we've not seen in a little while. She has been a member of 4 months. Risa, how are you, my darling? And Debbie Frank became a new member. Welcome, welcome, welcome. Always good. Always good. So mark out the plans for Wednesday night misdemeanor. We have, just give me a second here. Debbie Frank, thank you so much. You are so generous. Sent over a little Venmo. You're the one. You're the one. Thank you. And love you, my darling Debbie. Thank you so much. That's very sweet and kind of you. Remember Wednesday night, Janet misdemeanor. Thursday night, help, I'm haunted. Friday night, take off, get ready, and then Saturday night we're on. Now, I'm trying to make some pretty big plans for Halloween night. That is a Friday night. I know some of you take your kids, you go out, there's parties, there's trick-or-treating, there's all kinds of things. So Halloween night, my darlings, because it doesn't feel that good when it happens on November 1st, because we're going to have our little seeing crime on Saturday night, but it's going to be November 1st. So hang in there. AMC Fear Fest starts on the 27th. I wish there were a way that I could stream a movie or two on here, but I can't because of copyrights. But I will tell you this. You know that my son plays. He is a professional streamer. He plays in tournaments and gaming and so forth. He has agreed, and there's a certain way I have to do it, but he's agreed to let us stream while he is playing one of his very scary games, and most likely it's going to be about zombies. And we're going to be here, and we're going to watch him play. We're going to talk about it. We're going to have a good time. We're just going to do all kinds of things and go from there. There you go, Debbie. You go and do your thing, darling. There you go. And let us know when you're up and about. So, oh yeah. Halloween is going to be, the month of October is going to be very good. Okay. So, and look, we've got a new member, Nemore K-Bell. Thank you so much. Thank you, my darling. Appreciate you. So we've got all kinds of things. Cool is on. It's a good game, but we have a few choices, and you're not going to see him because he doesn't put the camera on himself. He will stream without a camera, but you'll be here. He'll be here, and he'll even do a little bit of the what do I want to say? Christopher Walken that he does. So there you are, my darlings. There you are. That's what's happening. So I want to thank you for being here. This is the start of season 3, phase 3, 3.0 for Karen Reed. I cannot wait. The faces on these people, I just cannot wait. When we hear from Nan, I'm going to invite her back at the very soonest that she can come to. We're just going to have a lot of fun, and that's what it's all about. Thank you, my darlings, for being here today. I sure love having you. Be well, and you be safe, and I will see you again very soon. I'm sorry I'm not going to have Manifestation Monday tonight. I got to recover a little bit, and I got to catch up on these videos for these dear people. So thank you so much, my darlings, and I will see you again very soon. You make my day. Bye for now. And so, the lantern fades, but the shadows remain. This story may end here, or perhaps it's only just begun. See you soon. Now, just as I get ready to leave, Kelly gifts 5 Lady Zelda memberships. Bless you, my darling. Thank you. Thank you. I love it. I love it. I love it. Thank you again. And plus, I played the wrong outro. But okay. You know, those things happen. So, and that gives me a chance to play the right one. So thanks again, my darlings, and I'll see you soon. Thanks, Kelly. Bye. They'll tell you the facts are clear, but the truth always flickers between the lines. In every shadow, there's a secret that refuses to stay buried. Clues hide in symbols, and sometimes even fate won't show its hand. Voices echo not just from the living, but from the silence they leave behind. I'm Lady Zelda. This is Seeing Crime, where what's hidden doesn't stay hidden for long. Until next time, keep watching.